Thank you very much. Good afternoon. Let me put this here. Well, my goal here today is to discuss this amendment to the Brazilian Constitution, establishing the land where labor analogous to slavery has been identified should be expropriated without compensation and allocated to agrarian or urban reform programs. So this is new. This amendment was enacted in last June, so June 2014. But I actually would like to start with something that's not on the paper that was pre-circulated amongst you. Going back to the empire in 1824, we could ask ourselves, was slavery a constitutional issue? Brazilian constitution didn't mention actually the word slavery or slave. It mentioned the word freedman. What's interesting about it is that in 1888, when we abolished chattel slavery, we did it by statute known as lei aurea, not by constitutional amendment. So one could easily acknowledge that slavery wasn't really a constitutional issue during the Empire ages. So how interesting. Now we are in 2014, and slavery has for the first time made its way into the Brazilian Constitution as a constitutional issue. But of course, what the amendment says is basically that property or real estate where contemporary slavery is identified should be expropriated without compensation and allocated to agrarian or urban reform programs. So my point is, what constitutional law can actually do about that? What can we really gain from involving constitutional law in this discussion about contemporary slavery? So I know that many of you are not familiar with Brazil, but here's a little map of Brazil, and the circles are marking the places where contemporary slavery have been identified. You probably will notice this complicated area at boundaries of the Amazon forest. This is the state of Pará with the state of Maranhão over here. And there is pretty much where much of the cases of contemporary slavery have been found. So if we take a look at 20th century Brazilian history, our penal code has been providing that reducing a person to a condition analogous to that of a slave is a crime since 1940. So it's been a long time in our in our criminal statutes. But the problem is that, apart from some criminal law commentators, this has been a forgotten provision for many years. So what happened? Actually, in 1940, this was a crime. In the late 1960s, 70s, and early 80s, some big economic enterprise moved up north. So we are talking about the military dictatorship, and the military dictatorship sponsored lots of infrastructural projects here in the Amazon region. We're talking about steel industry settling in. We're talking about railroad and road building. We're talking about hydroelectrical power plants being built. So within these enterprises, huge contingents of workers were treated in an inhuman fashion. So this was hardly noticed by the Brazilian media, by the Brazilian press, or by the Brazilian academia, apart from some interesting reports wrote by mainly religious institutions that were keeping track of what was going on in this part of the country. So the first denounces come from the Pastoral Commission of Land, which is a body connected to the Catholic Church. And the government, of course, was happy to deny, saying that we are dealing with only mere routine violation of labor rights. There's no slavery. Why are you talking about slavery? But the conditions in which these workers were found were so shocking that these institutions decided to turn to slavery as the most radical legal concept available to describe them. So what I can say is that from the mid-80s until now, something really changed in Brazilian society. First of all, the military dictatorship has come to an end. And in 1988, we enacted a constitution deeply committed with basic rights. This constitution is still in force, and we could say that is the most successful Brazilian constitutional so far, because we have been living on a long period without serious institutional crisis so far. And also something very important, in early 90s, we incorporated most of the main human rights international treaties from the United Nations and from the Organization of American States. So this was very important too. The national press and the foreign press played a more active role. I can remember a story from Folha de São Paulo, which is a major newspaper in Brazil. It was portraying a 6-year-old girl picking cotton with a pacifier in her mouth in the fields of Paraná. And I know that this picture, it really moved the public opinion in Brazil. People were, we have to do something about this. This is not happening in the far hinterland near the Amazon forest. This happened here in the southern region of Paraná. So people could realize that this was a real issue, and the government would have to respond to that. And also, there was some international pressure, particularly by the ILO. At this point, government decided to officially recognize the existence of what we are calling contemporary slavery within Brazil, and try to come up with a plan to fight contemporary slavery. What was this plan? This plan basically involved the creation of mobile inspection teams. So, these mobile inspection teams, they are integrated response to contemporary slavery because they coordinate administrative officials from the Ministry of Labor. They coordinate these guys with federal police and with the Labor Prosecution Office. So, I'll try not to spend too long explaining what this Labor Prosecution Office is, but it's important to give it a few minutes. These guys, they are like the criminal prosecution, but they do not deal with criminal affairs, only labor issues. So they are supposed to protect the interest of the labor class as a whole, as an entity, not of each worker alone. And these guys, they can actually file lawsuits seeking what we call compensations for collective moral damage. This punitive damage that are related to the breach of rights that are not held by one person alone, but by the community itself. So, 2 words about this mobile inspection teams. First, they are proactive. So they won't wait for denounces. They are supposed to chase people that are involved in contemporary slavery. And second, they can set a number of independent legal procedures, administrative procedures, seeking, of course, the imposition of fines upon perpetrators, seeking criminal prosecutions, of course, seeking convictions, and labor lawsuits seeking these compensations for collective moral damage. So this is pretty much the results of the work of the mobile inspection team since 1995. So we're looking at almost 20 years of history. And this line shows the number of inspected establishments, while the bars will show the number of rescued workers. Rescued workers are basically the workers that were found in a situation analogous to slavery and rescued by these teams. There's not a total here in the graph, but it's more than 45,000 workers rescued during this 19-year struggle. And many establishments inspected. So, but we can see that from this point, the number of inspected establishments is still rising a bit, but the number of rescued workers is decreasing. What could maybe indicate that we're having some sort of success in the task of preventing contemporary slavery to take place. But how could that be? So, before I elaborate a little bit on that, let me show you the activities in which contemporary slavery has been most commonly employed. And we can separate it in rural slavery and urban slavery. When it comes to rural slavery, we can see slavery on deforestation, and deforestation, of course, is closely connected with building pasture for cattle ranch. And we can see it on illegal logging that can also be connected with building space for cattle ranch, but it's also connected with the charcoal industry. The charcoal industry, for its turn, it's very important because it provides material for steel industry. And the steel industry is very powerful in the north part of Brazil. Also, we can find contemporary slavery on agriculture, especially sugarcane. I don't know if all of you guys are familiar with this, but Brazil uses sugarcane to produce ethanol fuel, which is, for many people, a very bad idea, but we've been investing on this for a long time. But unfortunately, the cropping of the sugarcane is made by people. I tried to figure out about the real circumstances of these guys that are working to crop the sugarcane. But the situation is really terrifying. So you can look at the average. A regular worker can pick up something like 3 tons of sugarcane each day. So you can imagine how hard this is. There's a very beautiful work on the internet. It's called Slave Portrait. It was made by the ILO. And in this website, you can find some pictures of actual workers dealing with sugarcane in Brazil. So we also have urban contemporary slavery. In 2013, for the first time, it outnumbered the cases of rural contemporary slavery. This is a little sample of what we are talking about when we're talking about urban slavery. In a moment, you'll see that the legal definition of slavery in Brazil involves subjecting the worker to degrading conditions of labor. And if you take a look at this, you'll see what I mean for degrading conditions of labor. This is supposed to be a fridge. And this is just the mark of a major brand of textile industry in Brazil. Textile industry in Brazil has serious problems on supply chains. And the supply chains of this textile industry have been using intensively slave labor. But this is a sweatshop, and here, okay. So I've shown you that graph with the rescued workers and the number of inspected establishments. But as you can imagine, when you're dealing with that number of workers, more than 45,000, soon enough, the mobile inspection team's effort showed the government that a more sophisticated response was in order to fight contemporary slavery. So we can also speak about some structural outcomes of the work of these mobile teams. They influence some changes within the government structure, the way that government approaches the policy to fight contemporary slavery. The first, in 2002, Congress passed legislation qualifying rescued workers for unemployment pay. This is, it looks very good, but it's not that good actually, because this unemployment pay lasts for only 3 months. So it's still evolving, but it was an important measure by that time. And in 2003, we have the enactment of the National Plan Against Slavery and the creation of the National Council for the Eradication of Contemporary Slavery. Basically, this plan tries to describe what are the policies developed by the Brazilian government that are somehow connected with the fight against contemporary slavery. And it tries to explain how these policies can interact and build synergy to fight contemporary slavery. And this National Council is the body responsible for overseeing the implementation of the plan. Sorry. It's interesting to point that this council, it's not only composed by government actors, it also has civil society actors composing the council. In 2004, the government decided to go public with a list of the companies that were caught exploiting contemporary slavery. This is very important, especially because we have some companies just like Zara, the big cloth industry from Spain, which has been using contemporary slavery in its supply chain. And it had to settle an agreement with the labor prosecution office saying, okay, we'll take responsibility for our supply chain and we're not going to do this any longer. Otherwise, we have to pay serious compensation. And this compensation, it's important to say, is not paid for the workers themselves. It's paid for institutions of public funds that are connected, which has a responsibility of promoting initiatives against contemporary slavery. So, and moreover, on the top of this, we have a consistent work of the Labor Prosecution Office throughout the period towards judicial convictions based on collective moral damage. So this is basically what we have as structural outcomes of this groundwork of the mobile inspection teams. So probably the most important outcome of this work is on the legal side of it, because we passed a new definition of the crime of contemporary slavery in 2003. I guess that I told you that in 1940 the Penal Code said in a very laconic style that it is a crime to reduce someone to a condition analogous to that of a slave. But that, of course, is a very complicated provision when it comes to criminal law. And that's very broad, and it's very difficult to deal with that. So we decided that we should elaborate more on what kind of situations really involve contemporary slavery. And the statute passed in 2003 basically says that it configures the crime of enslavement to subject a person to forced labor, debilitating work days, or degrading conditions of labor. Oh, I know that for many of you familiar with international law, forced labor is not slavery in international law. But Brazilian law makes it slavery. And we can, of course, discuss at the end of my presentation what is the real meaning of this, and is this good, is this bad, how can we deal with that? But the other two aspects are very important because they are in the core of the discussion that is happening right now in Brazil. What are we calling degrading labor conditions, or degrading conditions of labor and debilitating work days? So the courts in Brazil say that degrading labor conditions may include work sites that lack bathrooms, that provide no potable water, water is sometimes muddy, or water is shared with animals, this is very common, where only spoiled or very limited food is available, or where protective personal equipment is not used while performing hazardous activities. Disproportionately low wages can also be categorized as a form of degrading condition of labor. And debilitating work days. Debilitating work days refer to conditions of a worker being continually obliged to perform labor, so exhausting that it prevents his body from recovering and ultimately jeopardizes his health and deprives him of family and social life. So this is what we consider to be degrading conditions of labor and debilitating work days. So next, we got basically debt bondage. So restricting by any means a person's freedom of movement under the guise of a debt undertaken with the employer or with someone entrusted to act on his behalf. Restricting a worker's access to proper transportation, or maintaining guards at the workplace, or retaining documents or personal belongings with the intent of keeping him or her in the workplace. Basically, these are the situations that would describe contemporary slavery in Brazil, and that is the water that one of the inspection teams actually found on a work site. This is the water available for the workers for taking a shower or even drinking. The only water available in many miles. So I guess this is enough for a brief background information about contemporary slavery in Brazil. What does the amendment do? The amendment says basically that we're going to expropriate land in which contemporary slavery has been found. But let's understand this a little better. First, expropriation in Brazilian constitutional law is a complicated affair. We have some kinds of expropriation, and if the government wants to take away your property for instance, building a road, it has to follow certain legal procedures, and it will pay you in cash in advance, and then it will take over the property. But there are forms of expropriation that are almost punitive forms. So if you are a farmer and your farm produces nothing, you're just holding the property of the land for the sake of speculation, then the government can declare your land of public interest and can expropriate it, and it will compensate you, but not with money, but with public debt bonds, and that's almost a punishment when it comes to Brazil. So this has to do with the constitutional principle of social function of property. For those of you familiar with Catholic social teaching, this is very close to Catholic social teaching, and it's pervasive in the left in Brazil. So people would turn to this idea to describe the situation in which, okay, the Constitution will protect property, but only in the extent that property is being used with a legitimate purpose. So if property is not being used in a legitimate purpose, then the constitutional law will not protect it. But there's an even more radical form of expropriation, And in the original text of the Constitution of 1988, it was said that if somebody is using the land to cultivate illegal psychotropic plants, then you can take over property without compensation. So this is so severe violation of the social function of property that you just lose the land. And the idea, since the mid-90s, people who were fighting against contemporary slavery said, you know, we should add contemporary slavery to this provision. So if you can find somebody exploiting contemporary slavery within property, then you'll be able to expropriate it without compensation. And this amendment, actually, it was being discussed within Congress for this last almost 20 years. And it has just been enacted in June of 2014. So basically, the idea was to add contemporary slavery to this constitutional provision about expropriation. The amendment then authorizes expropriation without compensation. It encompasses both urban and rural property. And it says that these properties will be assigned for rural or urban reform programs. And any other personal property employed in the illegal exploitation of contemporary slavery will be seized and incorporated to a special public fund used according to legislation to be enacted by Congress. Basically, this is what the amendment does. So, what could be interesting for us here today is maybe discuss the prospects for such an amendment. What can we expect for such an amendment that finally made slavery a constitutional issue in Brazil? Let's talk about some problems that we should face very soon in Brazil. First of them, we have the problem of legal ownership of the land. So, expropriating land. When you're talking about expropriation, you're assuming that the perpetrator is the legal owner of the land. So this could be a problem, because a recent estimate from the Brazilian government said that something around 247 million acres of land are illegally occupied in Brazil. This is roughly 12% of the Brazilian territory. So, moreover, as I mentioned, the boundaries of the Amazon forest is a place where many cases of contemporary slavery have arisen. And this NGO called Amazon, it estimates that in 2008, 40 million hectares of illegally occupied public land existed in the Amazon forest. Probably this number has experienced some improvement, because in 2009 the government enacted legislation to deal with the problem of illegal occupation of public land in the Amazon. And I know that this measure has been somewhat successful. So this number could have been lowered a little bit since 2008. And finally, some geographers that do lots of field work in Brazil estimates that half of the land titles in the country are forged or illegal. This is, of course, an estimation. We shouldn't expect it to be accurate. But to hear that from a person that's actually involved in lots of field work makes you think that, oh, if this guy is half correct, then we still have 25% of this. It's worrisome. So this would be the first problem. But we should also ask ourselves, can this expropriation clause have some deterrent effect? Will it discourage the employment of contemporary slavery by economic enterprises? We don't know, but the fact is we can compare it with the available responses, the so far available responses. And they are the administrative fines imposed by labor inspection. And in the last 14 years, these administrative fines reach an amount of approximately $36 million. So this is not very much, especially considering that we are talking about 45,000 workers. It's $800 compensation for each. So pretty modest, and it won't help much. You can add to that the unemployment payment, and then you have maybe the worker with $1,600, let's say. Let's put it that way. This is not enough to prevent this person to being captured by the structures of contemporary slavery again, and it happens all over. It's very common for that mobile inspection teams rescue the same worker more than one time. So, criminal convictions. One of my colleagues, that's also a distance scholar at the University of Michigan these days, Professor Carlos Haddad, is also a federal judge in Brazil. And he served in the Federal District Court of Marabá in Pará, and he decided upon many cases of contemporary slavery. And he provided me with some information about the statistics. And what I can tell you is that we have 13 final criminal convictions out of almost 200 lawsuits. And only one of these final criminal convictions actually ended up on imprisonment, because the punishment is not that high, like it's 2 to 8 years of imprisonment. So we cannot expect criminal law to play a very active role in the fight against contemporary slavery here, at least so far. And finally, labor convictions for collective moral damage. All right. Data again is scattered here, but the press tends to report situations that involve convictions that are not final, that are still subject to appeal. So when you take a look at the final convictions in labor courts for collective moral damage, you see that they are around $3 million each. So only the final convictions, we don't know the precise number, but there are not many. But if we look to the expropriation, so a little information about the price of the land in Brazil. It's not as expensive as it is in the United States, but at the most valuable spots in the center of the country, today it's being used basically for soybean plantations, land can reach $17,000 an hectare. An hectare is roughly 2.5 acres. So you can imagine that a 400-hectare farm is small when it comes to Brazil. It's very common to find like 10, 20,000 hectares, farms of soybean plantations or sugarcane. It's not uncommon. So if you spot contemporary slavery on a farm this size, we could be looking at compensations up to $170 million or more. So at least on paper, this provision certainly has more deterrent effect than all the others. But of course, we need to see how this will really work. And we can also foresee some complicated enforcement issues. When I talk about enforcement issues, I'm talking about discussions that have been happening within the courts. And they have been happening not because of contemporary slavery. Of course, contemporary slavery has just been enacted. But we had expropriation clause for land in which illegal cultivation of psychotropic plants were found. So in these situations, the courts have been discussing what can we do if we find that a small piece of a bigger property is employed to cultivate the illegal plants. What about the rest? So the Supreme Court settled the issue and said, it's the entire property. So all right, if the guy was planting like in 1 acre of marijuana and 100 acres of sugarcane, then he will lose the entire property. But of course, when the Supreme Court made this decision, the Supreme Court was addressing small, hidden, cheap pieces of land used to plant drugs. How will this precedent respond to the situation in which you have like a 20,000 hectares soybean farm in the middle of the country worth up to $300 million? So we have to pay close attention to it, because I'm not sure if the current precedent can hold up against that. And another problem is that dealing with the expropriation of personal property connected with drug trafficking, the Supreme Court also said that if you want to expropriate, you should be able to demonstrate that this property has been used continuously and reiteratedly for illegal activity. It's not enough to show that it's connected with drug trafficking. You have to show that it has been continuously connected with drug trafficking. And this can bring a serious uncertainty for the expropriation clause, of course. Moreover, the prospects for the new amendment had to deal with the lack of information. We have very few organized information about all these aspects. We don't know much about settlements established in expropriated land, settlements established by former slave workers, how to transform a fully operational farm into an agrarian reform settlement. This is very complicated. There are many models of settlements. Some even support collective property. So how much public funding is available, we don't know, and we certainly do not know how to insert expropriated urban properties into a coherent urban reform. So I'm moving to the end so we can actually discuss. Another problem has to do with the enforcement legislation. And this enforcement legislation is basically that. The Constitution is very vague. It only said it will be expropriated and it will be assigned to urban or rural reform programs. Great. But how are we supposed to do that? What procedures should we follow? And the question also involves the legal definition of contemporary slavery, because if we take a look at the Brazilian legal regime, some might say that it is possible to apply or to enforce the constitutional provision without any legislation, because we already have the legislation available for the drug situation. So that would be perfectly fine, and I agree with that. But the Congress is disregarding this possibility because they want to discuss not the procedure applicable, but actually the legal definition that encompasses situations in which restrictions upon the freedom of movement are not involved. So what really bothers people is, should we call slavery some form of conduct that does not impose any real restrictions upon the freedom of movement of a person? This is the problem. So basically, I'll go very fast with this. Basically, a legal procedure. When it comes to land use for drug cultivation, you see that the police will issue a report. This report will be brought to court, and there will be criminal prosecution and a separate expropriation action. They will run simultaneously, and they will communicate only if the criminal decision is an acquittal or the recognition that the crime never occurred. So then the expropriation action has to be terminated. But what these guys are proposing in Brazil for regulating the constitutional amendment is basically that the separated civil lawsuits, they will still exist, but you have to earn a final criminal conviction in order to go ahead with the expropriation action. And this is not only excessively time demanding, but it can be easily circumvented because first, you cannot criminally prosecute a company. So if a company owns the land, there's nothing you can do. And it requires direct conviction of the owner of the land. But what about if a tenant farmer is working the land? If another person is working the land, then property will remain untouched, and this constitutional provision will serve to nothing. About the legal definition, what I can tell you is that Brazilian legal definition of slavery relies on the idea that contemporary slavery is a violation of human dignity, not a violation against freedom of movement. And that's why we're talking about debilitating work days or about degrading conditions of labor. The debate is basically, should we omit these two circumstances from the definition and keep it restricted to the situations in which some form of curtailment of individual freedom of movement really happen, or should we keep it? I believe that it's very complicated to simply abandon the legal definition because the constitutional amendment has been passed precisely relying on this perspective, so it's a sort of a covert maneuver. It's a kind of a fraud against the Constitution. But it's very difficult to actually make a court rule against this legislative change because the constitutional amendment actually gives that much space for the legislation to regulate. So that can be a problem. Finally, of course, my idea here is to discuss all of this with you, but we can think of some very interesting questions. When it comes to Brazilian law, I guess that we should think about the role of criminal law, because criminal law is not being effective in the fight against contemporary slavery. There are few final convictions. we have conceptual disputes over the legal definition of slavery. You probably noticed that the legal definition of slavery in Brazil is pretty different from the legal definition of international law, particularly 1926 definition. And I've been talking about that with Jean Alain from Queen's University at Belfast. And he has been at Brazil interested in discussing this. And basically, we have the problem of constitutional change and social change. Brazilians are still insisting in constitutional change as a form of social engineering, and this just doesn't work. So thank you very much for your attention.
Thank you, Leonardo, for a very eloquent and disciplined discussion of a vastly complicated topic, and we've got lots of time, and I've got to keep going, but I invite you to join it. So let's start with Gary, and I'll put more on.
Yes, thank you very much. I found this talk very interesting. I'm a property lawyer from Norway in Scandinavia, and this is not what we are used to when it comes to our jurisdiction. And you raised a lot of interesting questions from a legal point of view, more like what a lawyer will look into, and maybe we could discuss that later. But I have one question. When you prepared this constitutional amendment, did you search around and look into other jurisdictions and other constitutions to find examples of this one? Because I can't, here and now, think of another constitution that has got such a expropriation clause.
Yeah. Actually, we don't. So this is very peculiar, because the constitutional amendment is the result of almost 20 years of fight against contemporary slavery from these mobile inspection teams. Back in 1995, when they started their work and they started to discover what was really happening in the country's hinterland, they figured out that they should be able to describe the situations not only as a mere routine violation of labor law, but as actually as a violation of human dignity. Then the problem is, many ideas appeared in the mid-90s, and one of those ideas was to enact this amendment that will allow the expropriation. But this, as far as I'm concerned, when it appeared, it had much more symbolic meaning than it was an actual policy. Because you can imagine that Brazil is, in Brazil the issue of property is critical. If you take a look at the 1964 coup d'etat, you'll see that one of the things that weakened João Goulart's, the then president, position was his defense of agrarian reform. And so this is an explosive issue in Brazilian politics. And saying that you will expropriate land if the farmer exploits the worker in a fashion that can be described as contemporary slavery has the symbolical approach. But many people hailed this amendment when it was enacted as a second abolition of slavery. I seriously doubt that. That's why I finished the paper with Eric Foner's quotes and William Morris about the ambiguities of the outcomes of emancipation fights. This is bound to be something like that if we don't pay close attention to the developments. It's very complicated to enforce this constitutional provision, and the legislative struggle is showing that it can be even more complicated than we anticipated when we debated the issue in Congress.
I guess my questions have to do with the process by which definitions were formulated, and whether the forms of definition that were given discussion sources. And I have a particular reason for asking that, but I'd much prefer to hear your answer first.
Yes, thank you, Professor. Actually, I believe that the legal definition in Brazil is basically a result of the work of the mobile inspection teams. There were some scholars involved, particularly one professor of the University of Brasilia, Professor Elo Vieco, who is also a criminal prosecutor in Brazil. But definitely, she was looking at the work of the mobile inspection teams. These guys, they developed a manual to register what they were actually finding in the field, and they tried to organize this information into actually guidelines that would help people to understand what was the situation. And I believe that this reference, for instance, for degrading conditions of labor, you won't find this anywhere else. But this is very present because in Brazilian rural labor, you'll find that situation of the water or the food. So this sort of conduct that will equate man to beast, this probably was the most striking thing for the inspection teams. People and workers were living just like the animals. They were sharing the same water. They were eating the same food, sometimes spoiled food, sometimes very limited food. And I believe that this, at least this particular approach to situations that do not relate with curtailment of individual freedom, this is peculiar from Brazil.
The reason I ask is that the definition that depends on ideas of degradation, extreme dependency, social isolation, indignity, all of this conforms very precisely, well, as precisely as one could wish, to Orlando Patterson's definition of slavery. Slavery is social death. So I mean, in other words, which is a study, a sociological study based on a more or less systematic comparison, well, Patterson would like to tell you, of every significant slave system occurring anywhere in the world from antiquity through modernity, well, through the late 19th century. So I mean, there is a basis outside simple, well, no, not simple, outside the singular experience detected by the inspection teams, rather what the inspection teams are finding and describing conforms quite precisely to Patterson's scholarly analysis of slave systems. Patterson disputes a property characterization of slavery. Patterson wants to find or wants to persuade his audience that slavery exists in the condition of the enslaved rather than a definition of the enslaved as, in some sense, owned. But it does occur to me that there might be some mileage in Patterson's work for those seeking sort of to inject some kind of element of rigor into the definitional question.
Yeah, definitely. Thank you very much. I'm not familiar with Patton's work, but what I can say is that I find this Brazilian definition, although I'm not sure if Professor Jean Alain would agree with me, I find this definition at least compatible with the international definition. Mm-hmm. It's not actually involved in the international definition, but if we take a look at the Bellagio Harvard Guidelines, a document prepared for a group of scholars discussing the problem of contemporary slavery and elaborating on the 1926 convention, we'll see that at some point they will talk about like destroying the thing, destroying the property. If you exercise powers attached to the right of ownership over a person, then you are actually enslaving this person. Mm-hmm. If you exert control tantamount to possession. And I can see that in Brazil, and I can see that when you subject a worker to a situation where he has no water or no food. I believe that we are able probably to make connections between this situation in Brazil and not only legal definitions, but probably some sociological and historical work. I guess that's why Professor Rebecca Scott, who has been working with me on this back in Michigan, is so interested. She's a specialist in chattel slavery, 19th century slavery, but why is she looking at this? Probably because she can also envision some kind of connection between all this discussion. And I'll be happy to take a look at Patson's work and try to learn more from it. Thank you very much.
Go on. Well, Professor Tomlin's point was a really helpful comment. As a springboard for the question where I'm going with this is that I was rather perplexed with the idea of the remedy here being a property remedy to what is conceived as a human violation. And I get that if expropriation is indeed the remedy one wants to pursue, then why not look to other expropriation remedies that have been devised in the past? You mentioned one has been devised for as punishment for people who've been found to have been growing, was it psychotropic drugs specifically? Yes. Yeah, see, the thing is, that makes a lot of sense to me, coming up with an expropriation remedy for something like a conviction for growing psychotropic drugs. The information costs are so high of trying to figure out where are these drugs going to, that it makes sense that we think of that as some kind of property violation, and in such an instance, let's make sure that the property owner isn't able to grow more of the drug. What is less intuitive to me is how that then can be extrapolated out to a remedy for a conviction for contemporary slavery, especially in light of this point that you make that it's possible that there's so much property in Brazil that isn't even owned by the people who are actually administering what goes on that territory. So if you're trying to find some way of devising a remedy for a human violation, why then the property remedy?
So I guess that, as I was saying, this has to do with Brazilian particular situation when it comes to property of land, especially property of land. First, there's this symbolic dimension. You can see the Catholic Church with Pastoral Land Commission always criticizing the big landowners and their disregard towards the workers. And probably people look at expropriation not only as a symbolic answer, a symbolic response, but also as an economic response. They are trying to find a way to discourage economic enterprise to turn to contemporary slavery as a way of making more money. Basically, I can see it that way. There's also, but you can say that there's also the criminal aspect of it. You can still criminally prosecute a person for enslaving another. The problem here in Brazil, and I didn't mention that, is actually that if we go back to the definition, you'll see that we now attached the definition of contemporary slavery exclusively to labor relations. So this is a problem, because in the 1926 definition we have much more stuff. It's not only about labor relations. We have some forms like of servile marriage, and that's not encompassed in the Brazilian definition. One could ask, does Brazil comply with its international obligations by using this definition? Then we have lots of other questions. But I believe that the answer for your question has to do with symbolic and economic dimensions. We are trying to figure out a measure that will not only attack this culture of big landowners in Brazil that are disrespecting labor rights of the workers. Until 1988, the rural workers have very few rights in Brazilian law. It was a huge struggle to actually ensure that they will have some rights in the 1988 Constitution. And there's also the economic aspect of it, because we have very valuable property involved in these expropriation issues. And there's still the criminal response to deal with the offense to human dignity. So this definition is not only used in criminal law, but it came from criminal law, and it's still on the penal code. So you can still say that it's a very complicated, a very severe, very gross offense to enslave someone according to Brazilian law.
It seems to me that a lot of people are having trouble with the use of the idea of degradation as part of the definition of slavery. I think many people sitting around the table would think of degradation as a consequence rather than the definition of the phenomenon. And probably you could find people who would argue that certain well-recognized and compensated work roles may be degrading, even if they're well paid. In other cases, people who are legally, in some systems, legally slaves, may find themselves better treated materially than free laborers, but slavery still seems to be a useful concept of those.
Yes. Yes, that's a point. And many people in Brazil will say that actually this is the real situation of the work on the fields in Brazil. So this is just the discomfort that the regular rural worker has to face on daily basis. But actually what the mobile inspection teams and the inspection from the Ministry of Labor is saying is something different. We are not taking this definition lightly when we say that there are degrading conditions of labor. There are conditions that are really unacceptable for a person. Of course, we cannot expect that all the inspectors have been very coherent and very serious applying this provision. Some mistakes probably have been made, and these mistakes, of course, triggered a huge response from landowners. Now, you don't want to have your property dependent on the evaluation that an administrative official will do about the conditions of work that you are offering to the workers. So this is worrisome for many people in Brazil. But that's why in the legislative struggle that's going on nowadays, we are discussing, let's scratch this from the definition, because it's too complicated. But then we have a problem, because most of the cases in Brazil have to do with degrading condition of labor and debilitating work days. There are very few cases involving actually restrictions, actual curtailment of individual freedom of movement. So this is a kind of stalemate. If you alter the legislation to a more stricter definition of slavery, then you run the risk to make all the efforts of the constitutional amendment useless. That's the point. But of course, it's not very common to associate degrading conditions of labor to slavery. But the Supreme Court in Brazil had the chance to look at the situation, discussing a case involving a congressman. Actually, there are some congressmen that are being prosecuted for contemporary slavery in their farms. And the Supreme Court said basically that as a violation of human dignity, no curtailment of individual freedom of movement is required for the configuration of the crime of slavery. So any of that situations isolated can be described as the crime of enslavement. And this is, of course, generating all this discussion. So you are correct to think that this is somewhat unusual from the Brazilian law, but there's a reason for that. And that actually, we have been discussing this for 20 years, and the situations with these workers are sometimes very, very severe. And I wonder if the best way, I really don't believe there's what I could say, authentic definition of slavery. We're not seeking an authentic definition of slavery that would rely on the 19th century imagery of slavery. So where are the chains, where are the shackles? And no, this is slavery. But slavery as a legal definition, it can change, and it can, of course, vary from one legal culture to other. It can be puzzling, but it has been working in interesting ways, although, of course, there are problems with the enforcement of this provision by administrative and judicial authorities. There's no doubt about that.
Sorry,
I'm interested in hearing you say something about the connection between the mobile inspection teams and the occupations by the landless movement. And in particular, it's my understanding that in some cases the occupations, they would stage an occupation and discover slavery and then call in the mobile inspection unit. I don't know if that's a typical scenario or
I don't think it's a typical scenario, but one of the interesting things about this amendment is that it's supposed to do two things. First, fight and prevent contemporary slavery. Second, foster agrarian reform and urban reform as well. I believe that it could succeed in the first, but it's very hard to succeed in the second. And why is that? If you take a look at the government's agenda, the more Brazil grows dependent on the trade surplus generated by agribusiness, less space agrarian reform will have in the government's agenda. So the information in the paper, I provide you some information about the amount of land that is actually expropriated for urban reform. It's like decreasing dramatically. And then I'm really sure that people from landless movements in Brazil, they are supporters of the idea of fighting contemporary slavery, but they are also maybe thinking that they can provide the ideal model to occupy this land that will be expropriated with collective property. And but I'm not an expert on that. I think it's hard to evaluate if this can work. But if you have very big economic enterprise on the field, very big agribusiness enterprises, I really have trouble to understand how this can be transformed into a successful settlement for agrarian reform. So the concepts are really, it basically relies on agricultural family. So
I guess my question was more because my understanding is that they usually target precisely those properties which would fall under the social
Yes.
function that were at risk
Sure.
of being, or at least that they could present a plausible case of expropriation due to the failure of the
yes,
landowner to
but in this
develop the
case,
land
yeah, but when they invade a land, a piece of land, they are usually saying, oh, this land is not fulfilling its social function, but in another way. It's not being productive, it's not being used for anything, it's used for speculation. But sometimes they can invade using this argument, oh, there's contemporary slavery, so it's not fulfilling its social function. And then we can invade, and we will invade to at least to expose the situation. But it's not the most typical scenario. The most typical scenario is this mobile inspection teams. They can, of course, they can be tipped by social movements, by the MST, this landless movement, by Catholic Church. They can be tipped by a bunch of persons. But usually they have intel from the federal police. And they organize these inspections exactly to discover in which, in some specific regions, which farms are employing contemporary slavery. And they organize big raids, and they try to cut this landowners on the act. So discover them, exploiting these people, and describe in very detailed fashion what were the conditions of those workers.
Sure.
Yeah, just about one other action that the workers. You don't really speak about the workers and maybe their unions and their resources or not, so that's not like slave. Studied by Thomas last week. There is a court, there is a team mobile inspection, and how they do to fight against the situation where they are, or are they only passive, these workers, enslaved, or not?
Yes. One of the problems of employing this word slavery, and many people say that in Brazil, is that you're somehow stealing the agency of this person. Oh, he's a slave, he's an enslaved person. I've never came across with anything that was produced by former victims of enslavement, like a manifesto, a declaration saying, we are being subjected to terrible situations, we think that our situation is a situation of slavery. I'm not sure that these rescued workers like to identify themselves with the idea or with the imagery of slavery. And I definitely think that the unions are not a big player in this discussion. So, but we're actually talking about illegal immigrants when it comes to urban slavery, or we're talking about very poor, illiterate, and unemployed people in the deep hinterland of Brazil. People that will laugh at you if you say that, oh, there are other languages than Portuguese in the world. So this guy said, no, not at all. What? I'll talk to somebody and this person won't understand that? Yes. So this guy won't believe. So we're talking about people that have very little formal education and that no conditions of living at all. So I really don't think that they relate themselves to slaves, that they can describe their situation as one of slavery.
Okay, but can they not use other rules than slavery or its definition to fight against the bad condition in their work? I think about a paper in French of Lydia Sigaud in 1996, the same day.
More or less the same
And
period.
it was about the strikes and the conflicts in rural area where there was a sugar production in Brazil, and she described how they use various legal tools and courts, small courts, to fight against the fixation of salary. And each year, you know, there was a fight between the employers and the workers. And it was very interesting because she showed how they used these tools. It was not about slavery, it was about condition, work condition, and the very low level of salary. So,
That's wonderful about legal history. There are so many possibilities. Usually it's hard to understand why something occurred in a very specific way. And I certainly can tell you why the things went in Brazil exactly like that. Why wouldn't we choose another different path, another legal definitions, another concepts? I guess that the more interesting for me now is trying to realize what we can do with the concepts and the definitions that we have. And if we're really trying to enforce this constitutional amendment, what are the alternatives? We shouldn't be naive to the point to describe this as a second abolition of slavery, even because the first abolition of slavery was very problematic itself, as many of the emancipation fights. So my point here is more to understand what can we do with constitutional law, getting involved in contemporary slavery, in the fight against contemporary slavery, and how can we avoid this many pitfalls, social, legal, economic, cultural pitfalls that are involved in enforcement of the provision, assuming that Congress made the right decision by enacting it, and we can of course doubt that it was the right decision, but I'm trying to assume the constitutional amendment as a starting point, actually.
So often happens you've provoked more thoughts and questions than we're going to have time for. But we do have time for one more, so I'm going to call on Dr. Toe here, and we'll then join me in thanking our sponsors.
To legitimize expropriation, we need discussion not only how the former landowner did use this land, but also we need discussion after this expropriation, the land will be used for what purpose? So I would like to know a discussion about this dimension. So how the amendment expects the purpose of land use.
Yes. The amendment says that the land will be allocated to agrarian or urban reform, but this is, of course, not clarifying how. I'm sorry, I'm not sure if I...
No.
I guess that the problem here is saying that land will be used to agrarian reform means very little, because there are many different ways of producing the land. There are many things to do, and there are many approaches to agrarian reform, different approaches. And in Brazil, we have like this Movimento dos Trabalhadores Sem Terra, that's landless workers movement, and they have a particular way of approaching expropriation and for urban reform, for agrarian reform. And of course, there's still the possibility, and this has been discussed in the legislative debates recently, to actually, if the land is not fit for agrarian or urban reform, then you can just take it and sell it. And you can use the money to foster initiatives to fight contemporary slavery. This is not an alternative, but of course, many people will say, well, come on, the Constitution says that the land will be allocated for agrarian or urban reform. So we'll have to explain why we're actually not using the land for that directly, but we are actually selling the land and using the money because it's more effective than using the land directly. I believe that this is consistent with the constitutional provisions, but this is a discussion that's still to be done within Congress, actually.
Let's not waste the opportunity. You have time for one more.
Sure, I'll just ask a quick question about the relationship between the people who were rescued. You put that in quotes, and of course you know that a lot of those people end up working
Again, yes.
in slavery conditions. I'm wondering what the definition of slavery based on dignity can do in thinking about responding to the needs of those workers moving forward. I know I saw there was some unemployment compensation in an earlier, 2002, that's
Yes.
at least a few months. And I didn't see too much more, and I think this follows on your question about sort of what the
once the law is implemented?
Yes. I really don't know where the policy to fight contemporary slavery is going after. It's difficult to envision what are the prospects after this constitutional amendment. We really don't know if it's going to work. But what I can tell you is that a very important part of the public policy to fight contemporary slavery has to do with education, basically providing these workers conditions to be assimilated in the market. But this again is very difficult because the only thing that they can actually sell is the workforce. And if you take a look at the activities that they are performing, they are very basic activities like cutting grass, like logging, and like putting the wood into the ovens for making charcoal and stuff like that. So they're basically being used as beasts of burden. But of course, what are the alternatives for these people? How to build an alternative? I'm not sure if the government is prepared to build a definitive or very consistent alternative as a public policy. But I really hope that it does involve conditions for at least preparing these guys for another kind of function within the economy. But it's easier said than done. I can't figure out how this could actually be achieved, you know. But I'm not an expert in public policy. But if I were, I was trying to look at it as how should we provide these guys with information that can be useful to, and of course the unemployment payment plays an important role because it gives you time to learn something. But again, easier said than done.
Professor Barbosa, thank you for opening a topic of just unparalleled interest and fascination. And I guess you'll be around for another few hours at least, and after that, you can definitely reach him at the University of Michigan, where he'll be for the rest of the academic year. So join me now in thanking him so much for presenting.
Thank you.